Thank you so much for your patience. If you have any questions, we have a Q&A session after my sharing. So you can type all your questions in the chat box below. And after the sharing session, we will try to answer all of them. Let's start. I'm Veroni from 𝐈𝐏 𝐎𝐼𝐻, and today I will be sharing what a beginner should know about intellectual property. So these are some information where you can find and contact us. Our email is here, our contact number, and our website. So do check us out and follow us because we'll update from time to time. So I hope that after this sharing session, you will know how to protect your IP rights for your work. So what are the problems that you face when you hear about IP? A lot of people don't know how to protect their IP and they are not sure which IP rights their work falls under. Some may be confused that intellectual property means the real estate property. So in this sharing session today, I will explain as simple as I can about what IP is. So what is intellectual property? IP is not tangible property like cash or real estate. It is something we cannot touch and it does not exist in physical form. It is something we create out of our mind and needs intellectual effort. And that is why it is known as intellectual property. So what are the types of intellectual property rights that we have? Copyright. This actually protects expression of ideas like storybook, film, novel, painting, or music. Trademark is a brand or logo that you use to represent your products or services. Industrial design. This protects the external appearance of a product, like this design of the Coca-Cola bottle. Patent. This protects invention, and this includes certain products and processes that gives us solution to a problem. Plant varieties, layout designs of integrated circuits, and trade secrets are not so common. So I will be sharing more about the first 4 IP rights that you will encounter more often today. So let's take this smartphone as an example. The Apple logo is a trademark. When people see it, they know that Apple is actually selling smartphones and tablets. Copyright protects the photos you take, or when you listen to music, the music composed by artists are also protected by copyright. Industrial design. This protects the appearance of the phone, the sleek and elegant design of a smartphone. And patent. Smartphone is an invention because it has new technical features like the touch screen function or the thumbprint function when back then Nokia phones did not have. So a product or service can have multiple IP rights. So let me share the types of IP rights one by one. First, trademark governs under the Trademarks Act 2019. So what is a trademark? A trademark is a sign or logo. It represents your products or services. This means your logo or trademark can distinguish your goods or services from others. So your trademark must stand out when compared to other trademarks. And as you can see here, a trademark can be a logo, a brand, and even a slogan like the KFC Fingers Licking Good slogan. And after the amendment of the new Trademarks Act, now the spectrum is even wider. You can register for trademarks like colors, the Tiffany blue color, and shapes of a product like the Toblerone triangular shaped chocolate. When people see it, they know that the shape of goods is representing Toblerone. And now you can even protect sound as a trademark, just like McDonald's, da 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 da, I'm loving it. So it is quite diverse now, and So long as your trademark stands out, it can be protected. So, how can a trademark be protected? First, make sure that your trademark is distinctive. This means that your trademark can distinguish your goods or services from others in the course of trade. Don't use trademarks that are too generic, okay? It is better to use invented words or words that are not commonly used within the industry so that your trademark can stand out and be different. For example, Boost for fruit juice or Oreo for biscuits. Okay, next. The trademark must not be describing the nature, quality, the kind or characteristics of the goods and services. Use words that are not relevant to the goods and services that your business sells. For example, you can use Apple as your trademark to sell computers and phones, but don't use Apple as your trademark to sell apples, because if you do so, it means that you are actually describing the kind of goods that you are selling, and it cannot be registered. The third one is your trademark must not be identical or confusingly similar to other trademarks. So when people see your trademark and thought that your brand has a connection with some other brands, like, this looks like the Xiaomi brand, then your trademark will be hard to register. So make sure that your trademark is distinctive, not describing goods or services, and it is not identical or confusingly similar to others. You can actually engage a trademark agent or lawyer to help you conduct a trademark search so that you can see if your trademark is similar to any registered trademark before you. And also you can evaluate whether your chances of success in registering your trademark is high or low. So quite often you can see people using the TM sign and the R sign. Like the H is using TM sign here, and the Wiggles is using the R sign here. So what is the difference between these signs actually? The difference is you can use the TM sign when you have filed an application, but it is still pending approval. This means that it has not been successfully registered yet. But you can use the R sign when the trademark is successfully registered. Now, it is important to know that trademark protection is territorial based. This means that if you register your trademark in Malaysia, then it will only be protected in Malaysia. So if you want your trademark to be protected in other foreign countries, there are actually two ways to do so. The first one is the direct filing, and the second one is the Madrid system. So direct filing is actually the most traditional way to file an international trademark application, where you need to appoint a local trademark lawyer in those countries that you wish to protect your trademark to file the application directly. It is more expensive, but you will actually get the benefit of having their advice, and they are actually more well-versed with their local laws. So there is no need for a basic application or registration in their home country. And in our case, it is Malaysia. This means that you don't need to first file an application in Malaysia before filing an application in those countries. You can file them directly. And as for the Madrid system, it is a new system after the amendment of the new act to file an international trademark application. So under the Madrid system, you do not need to appoint a local trademark lawyer in that country if your application is smooth. So it is cheaper compared to direct filing, but to use the Madrid system, you must have already filed a trademark application in Malaysia, or you have already registered a trademark in Malaysia. So this is different from direct filing. And if you wish to protect your trademark in just maybe one or two countries, you can actually go for direct filing. because the cost is not too different when comparing these two ways. And you can have the benefit of getting the advice of the local lawyers. But if you want to protect your trademarks in a lot of countries, then it is more viable to use the Madrid system, because the gap of the cost will get wider when the number of countries grow. Now, you have to be very careful. Here is the catch for Madrid system: the central attack. If your basic application in Malaysia got cancelled or refused within 5 years from the date of filing the international application, then your international application will collapse as well. So you will incur additional costs at this later stage to transform your international application into national applications. And the process will be just like the direct filing, where you will need to appoint the local trademark lawyer in those countries. So this is one thing that you need to be aware of. Now, when you have successfully registered your trademark, the trademark protection lasts forever, so long as you renew your trademark every 10 years. And now you can use the R sign as I mentioned earlier. Next, copyright governs under the Copyright Act 1987. So what does copyright protect? Can I protect my ideas? The answer is no. Copyright does not protect mere ideas or thoughts, but it protects expressions of ideas. This means that if you have an idea about a story, the mere idea itself is not protected as a copyright. But when you write it down as a storybook, then yes, the storybook can be protected under copyright. To get copyright protection, you need to fulfill these requirements. So sufficient effort must be expended to make the work original, and the work is reduced into material form. This means that you have put in your time, skills, and effort to make your story original and write it into a tangible form, such as on a piece of paper, or you can store it in DVD or a USB. So some of the examples of the works eligible for copyright protection are literary works like storybook, computer program source codes, artistic works like painting, drawing, sculptures, photographs, sound recordings like music, musical works like plays, films like movies and dramas, or broadcasts like radio and TV broadcasts. All of these are actually protected under copyright. So, as a copyright owner, you have the right to have control over your work to make money. This is such as the right to reproduce the work, like printing multiple copies of your work and then sell them to the public, which is the right to distribute your work by sale. Or if you compose the music, you have the right to perform or play it in the public. And the right to commercial rental to the public means that if businesses are using your song in their commercial shops, then they will need to get a license and pay royalty fees to play your music in their shops. Now, you will think whether you need to register or not for a copyright protection. The answer is no. You do not need to register for copyright protection. You just need to fulfill the requirements mentioned just now, okay? Just make sure you have spent effort in making your work original and then reduce it in material form. Then you will automatically get the copyright protection. But you're always encouraged to apply for a copyright voluntary notification. Why? This is because in case someone suddenly comes up to you and say, hey, you infringed my copyright, then you may just use this document as a proof of ownership that you own the copyright. So to sum up for copyright, the protection is automatic, but you are encouraged to apply for the notification. And the copyright protection lasts a lifetime of the author plus 50 years after his death. Next, patent, governed under the Patents Act 1983. So what is a patent? A patent is an exclusive right granted to an inventor for an invention. An invention means a product or process that provides a new technical solution or function to a problem. So how do you actually get patent protection? The invention must be new, involves inventive steps, and it is industrially applicable. New in the sense that it is not disclosed to the public before. For example, before we had smartphones, we had Nokia phones without the touch screen function, thumbprint, or even the Face ID function. So the smartphone is a new invention. Inventive steps means the technical feature or the function of the invention is not obvious to the person who has the skills in that particular art. So if the touch screen function or the Face ID feature was not obvious to the engineer back then, it means that the smartphone has an inventive step. And industrially applicable means that it can be made or used. So if the smartphone is invented, but it cannot be used, then it is not an invention that is industrially applicable. So if your invention fulfills all the three requirements here, then a patent can be granted and you can get patent protection. But bear in mind that even though the invention fulfills the meaning mentioned earlier, these four inventions cannot be patented. The scientific theories or mathematical methods or the business model, the methods on how to do your business, unfortunately, they are not patentable. So if you are granted the patent protection, you have the right to exploit your own invention. This means that only you can use, make, distribute, sell, import your invention, and others are not allowed to do so without your permission. Second, you have the right to assign or transmit a patent if you wish to do so. This means you can actually transfer the patent ownership to a third party. And thirdly, as a patent owner, you have the right to conclude license contracts. This means that you can license out your invention to another person, and in exchange, you collect licensing fees from them. So even without using the invention yourself, you can earn money by licensing it to others. So for a patent protection, it lasts for 20 years. And unlike trademark protection, where you renew every 10 years, for patents, you renew every year and get up to 20 years of protection maximum. And lastly, industrial design, governed under the Industrial Designs Act 1996. So if you have a design which is unique and you wish to protect it, this falls under industrial design. Industrial design only protects the external appearance of a product, like shapes, configurations, or patterns. Unlike patents, which we discussed just now, industrial design does not protect the technical functions or the technical features of the product. So it only protects the unique outer appearance. For example, the shape of this whiskey bottle, the design of a gaming chair, controller, and so on. So what are some of the requirements to be protected as industrial design? First, it must be a shape or pattern which can be made to a product, and the design is so appealing to the eyes of the public. Not only so, it must be new globally, which means it has not been disclosed to the public before in Malaysia or anywhere. And it must not be contrary to public order or morality, which means the design is morally acceptable in the society. So if your design satisfies all these requirements, you will have protection over the design. If you have successfully registered the design, you will enjoy the exclusive ownership to your industrial design for commercialization. This means you can use the design and manufacture it into a product. You can also license your design to others, and in return, you can earn licensing fees from them. Or you can actually sell the products bearing this unique design that you have designed. So only you as the owner can enjoy these exclusive rights and others cannot. And for industrial design, you are entitled to a protection of 25 years maximum. And you can maintain your industrial design protection by renewing every 5 years up until 25 years maximum. In conclusion, the IP registration process itself is highly technical and it is decided on a case-to-case basis. Sometimes it could be smooth applications, and sometimes, even though you might face objections from the registrar, if your appeal is successful, you will get to enjoy exclusive rights that we have mentioned earlier. And especially when you have spent countless amount of time, effort, and money in building your work, you will not want to lose out and you will want to make the best out of it. So please register and protect your IP rights now. And that is the end of my sharing today. I'm Veroni from 𝐈𝐏 𝐎𝐼𝐿. I hope that my sharing benefits all of you. And before we end this webinar, let us invite our Mr. Lawrence to answer all of your questions in the chat box. Thank you.
Hi, thank you, Veroni. Hi, good afternoon, everyone. This is Lawrence from 𝐈𝐏 𝐎𝐼𝐿. How are you? How are all of you today? We have some familiar faces here as well among the audience. Thank you, everyone, all of you, for joining us today. Okay, so before I move on to the Q&A, I can actually add on some points that during the webinar, Veroni's presentations just now. Usually, right, when it comes to the trademark registration, we have actually encountered quite a bit of common errors from our clients. And also some of the inquiries that we have. For example, trademark, one of the common problems that we have seen is actually those trademarks that are quite describing the products and services that they are selling. It's not that this kind of trademark entirely cannot be registered, but somehow it might actually add on difficulties on the registration process. Sometimes you might encounter objections or encounter some refusal from the registry, and then we might need to incur more time and cost to overcome the objections, things like that. So in order to, a key takeaway on trademark registration, or if you are designing a new trademark, try to choose those names which are totally irrelevant to your products and services. For example, just now Veroni used a good example on the word Apple. Apple has nothing to do with computers or phones. So this kind of words, although it seems generic, but it can be registered as a trademark if you are interested in registering a patent and an industrial design. These two types of IPs, there is a requirement of novelty. Unlike trademark, we can do it something like I use for a while first, then I start register. Of course, from our perspective, we don't really encourage that. But somehow there is no novelty requirements on trademark. But when it comes to patent and design registrations, there are requirements on the novelty, especially industrial design. Let's say you want to protect the design of your bottle. So that bottle, if you plan to protect the design, right, before you start marketing or disclose it to the public, it's actually advisable for you to register it first before you start selling or publishing or marketing to the public, so that you preserve the novelty, because novelty is the first requirement for patents and design. When it comes to patents, Malaysia, we still have 1 year grace period of disclosure. Let's say you have disclosed to the public, and then you probably can wait for within 1 year you file the patent, but we will still encourage you to file the entire things before you even make it available to the public. Just now we were sharing about the use of the TM and R sign. That part Veroni shared correctly, where pending usually would use the word TM, and then if registered, they would use the word R. But don't misunderstood. Some people, if they don't put on the sign, doesn't mean that their trademark is not registered, because this is actually up to them whether they want to use it or not. But if to be safe, right, usually we will check the registry on their trademark status to make sure that whether their status is registered or not. If you have any questions, now I can actually move on to Q&As already. So let me reply to Bella's question first. Do trademark has a commercial value? For example, whether we can charge a fee to anyone who wants to use. Yes, trademark does have a commercial value, and don't confuse this. Registration, it actually enhances the value. Your trademark would have the value regardless whether you register it or not. But if you have been using your trademark for a certain period of time, and then you have enough publicity, that itself would create value for him. And then when you do the registration, you lock the commercial value towards yourself only. And then, yes, you can charge people for a fee for using it on the licensing. But on top of that, right, that is actually on the permission part. But you would need a very comprehensive licensing regime to decide how your licensee use the trademark. We usually, in the licensing agreements, right, it's not just as simple as, oh, I charge you X amount of fee and then they can use. No, we would suggest you to include the conditions. You better do a survey on a type of licensee and qualify your licensee who can use your trademark. And then throughout the use, what are the conditions they should fulfill? Because they will need to follow your branding guides. Because you do not want them to jeopardize your brand when they use your trademark. So on top of charging them a fee for licensing using your trademark, right, you will need to set down the conditions, how you like to use, in what circumstances they should use, the manner they are using, and whether when they do the marketing, whether they should follow your guideline or not, or are they free to do their own marketing, so that you would, or you would like to exercise certain control, or whether the marketing material should come from you, or they are free to do whatever marketing they want. So that would actually affect the commercial value of a trademark. And usually the commercial value, we can evaluate from the point of sales, and then the time of usage, and then the exposure, the kind of reputations that you have built up over the years. So when you have all this value, the registrations of trademark actually lock all this value, and then it enhances those value. So to answer Bella's question, yes, trademark does have a commercial value, but it depends on the sales and reputations that you have been building over the years. And yes, you can charge for a fee. So Bella, I hope I answered questions, but you have further questions, feel free to add on later. And can come to KY Tan. How long does it take generally to get registered locally and also through Madrid system? I assume KY means locally means Malaysia. Malaysia, for a smooth registration process, from the point of filing up until we get a certificate, if we don't encounter any objections or any queries from the registry, right? Usually it will be about 1.5 years. That is for smooth application. But some of the applications, maybe we encounter objections or we need to file further appeal, or maybe there are some oppositions going on that would actually delay and prolong the registration process. So if just a simple objections, it might actually drag the registration process from 1.5 years to maybe 2 to 3 years. But if we have oppositions, right? Let's say opposition is the fight between two parties over a trademark. So this could even drag longer. If the trademark registration involves opposition, both parties need to argue and then fight their case, right? It could drag up to 5 years or 3 years like that. So to answer KY's question, for smooth one is usually between 1 to 1.5 years. It seems a bit long, but not to worry about that, because the registration actually take effect from the date of you do the filing. But of course, if you want to enforce your right, you need to wait until you get your registration done. So let's say I filed the application today, and then I only get my registration certificate end of 2022 next year. So my protection period actually starts from today, not next year. But of course, we will have to wait for the certificate. And through Madrid systems, right, actually, there is no fixed time limit throughout the entire Madrid system. It will still need to go down to the local government trademark office, how soon they examine the application. But most of the time, they will come back with a decision within 1.5 years. If, let's say, you file your application in 3 countries, for example, Singapore, Thailand, and Philippines. So all these countries, they will have their own timelines. Some country could be sooner, some country could be later. So you will get decision based on the working pace of that particular country. Maybe you get decision from Singapore first, then maybe Thailand slightly later, things like that. And then each country, they might have their own decision as well. There is a possibility that this trademark you get registered in Singapore, but when it comes to another country, you are not getting registered. So Madrid system is not actually a system for us to register all the country in one go. It's actually just facilitate the process, make it easier and then more cost effective, easier to manage. But eventually you still need to go to the country one by one. And of course, one of the main benefit is the costs are cheaper under Madrid. So I hope I answered KY's question. I now move forward to the questions from Alison. I'm an Instagram content creator reviewing. Logically, I own the copyright of the video picture. But how about, yes, if those video and pictures are taken by you, yes, you still own the copyrights of those pictures. But unless you have others agreements between you and your clients, then that would actually reverse the position. So it really depends what are the agreements signed between you and your clients. So yes, I hope I answered Alison's question. And Su Yi, may I know what's the difference between registering IP by ourselves and engaging an agent? Okay, the difference is what you have submitted and how do you handle the process. Because registration of trademark, right, it's not like applying for license in some other government departments. This is actually a right for us to sue somebody. We are asking for exclusive rights. You see, don't confuse trademark registration with other commercial license that we are applying. For other commercial license that you are applying, we are actually applying for permits to do something. But when it comes to trademark registration, you are actually applying for protections. So the process could be quite lengthy. I think I've shared just now already. And it could be quite complicated because during the process, the registry might come back with some other issues or objections or things like that. And then you might need to respond to their issues. So let's say if the issues are not really beneficial to you and somehow you have agreed to the conditions, it would be better if you have an agent to advise you how to respond to that queries. And of course, if you have an agent with you, you have a better assistance on following up with the registry. But in terms of timeline, it's almost the same, just that agents would usually know how and where to follow up and why is it taking so long and where we actually got stuck. But most of the inquiries that we got where the clients come over to us halfway, the common problems that they face is they never received a letter from the registry because somehow maybe the documents lost in transit or maybe they didn't know, or maybe they don't know how to respond to the letter. So that is the difference between applying yourself and engaging an agent. Because first, you might unknowingly claim a wrong rights. Some people, they thought that, oh, I get the trademark registered, it's done already. But sometimes quite a bit of clients, when we look at their registrations, right, the protections, the scope of protections they are getting are not so accurate when it comes to their business. So when you have an agent, they would advise you how to properly cover your scope of business and then what are the things you should go first or you can go later according to your budget. So everything can be prepared and strategized accordingly. Okay, Suyi's second questions. For trademark, should we register our trademark first or start our business first? Okay, that actually down to your business operation. Let's say now you are about to start a trademark, maybe start a business next week, and you are very certain that you are going to use this trademark already. So I would suggest you register your trademark now. But at this point, you better make sure your trademark fulfill the requirements that Veronique shared just now, which means choose some words which are irrelevant to your products and services. But if you want to start your business operation, then you need to register your business first. Because running a business without registration in Malaysia is illegal. Before you even start your first sales, right, you better register as a sole proprietor or maybe 𝐸 Berhad or PLT. That is another aspect of business operation. But when it comes to trademark and business first, for trademark, I would suggest you, if permissible, you register before you even launch to the public. Because probably you already have a business now, and then now you are coming up with a new brand. Before you launch that brand with your products, I would suggest you to register your trademark first. But before you start your business operation, you definitely need to register your business first. So that actually depends which stage of your business operation is. So launching of the new brand, I would suggest you register first before launching. But talking about business operation, yes, you will still need to register your business first before you start running the business. I hope I answered Sui's second questions. Sui asked a very good question. A lot of people, they are starting their side business. but they are selling online without registering for their business. Registration or trademark and business are different things. Business is you will need to register with SSM. Then only you can start selling your products and services. But trademark is actually, we are registering for protection of your brands and protections of your logo. Theoretically speaking, you can use your trademark or logo even without a trademark registration. We are applying for trademark registration to stop somebody from using your trademark, because you don't want to go through that kind of predicaments like I have been using for half year or 1 year later, then only I decide to go and file the registration. And then when I go ahead and file registration, then only I found, okay, somebody take a step before me, they register before me already. Then it would actually make you into a very difficult position, because you might need to sue the person, or you might or might not have a grounds against him. You would actually make your entire operations very complicated. So we don't really want to get into that. Everyone, any more questions? Honestly speaking, this is our first time doing webinar. I hope everything went well. If there's no further questions, I will move on to the last part of my sharings already. I would like to share with all of you about this. We would like to share a bit about our website here. I would like to invite all of you, right, from time to time, feel free to come and visit our blogs here, because we are trying to build up our blogs according to issue specific matters. So it's not really only about general Q&A. You will notice that we prepare our contents specific to certain issues. Like last time, the 𝐈𝐏 all these stories, and then we have been putting up the 𝐕𝐵𝐵. For example, are the free photos on the internet are really free or not? This one is very interesting topics, because a lot of people, the time when we do marketings, right? A lot of people, they will tend to use the free image available on the Google image, which is totally not advisable. So I would like to invite all of you to sometimes, if you have any questions about IPs, right, you can just drop by our blogs here, come and scroll through. Maybe there are some issues that would actually help you to understand better. But from time to time, right, please feel free to send us a message, so that based on your questions, we can build up our contents here. We will probably we can write an article just based on one of your questions. Okay, so please feel free to drop by. If there is no further questions, we are coming to the end of our sessions already, but please don't go first. I would like to invite every one of you, right? You can actually help us do a little bit. Actually, this is the first time we do a free webinar online. So I hope that you can give us some feedback. But if we've done anything not good enough, we are sorry about that. But we hope that you can help us to give us some feedback, so that we see how we can improve further next time. You can scan here, go to the Google Forms and give us your feedback. So we will be doing more on webinar like this. This time is our first time. We will need to see what else we can improve from time to time. Then later, we will coming up with a series of webinar where we will have a more specific and more detailed sharing. The next one will be on trademark specifically, the registration process, what are the issues that you should look after, and then how to strategize and plan for your trademark registration in local or even globally. And then after that, we will start sharing more about patents, design, copyright specifically. Like you can see today, we are more on everything, general guides on everything. And then slowly we will also coming up with webinar in Chinese and other language or like BM as well. So please, we really welcome any critical comments. You can be as brutal as you want. We just like to improve from there. We really appreciate that. Thank you very much. Okay, do we have any more questions from the audience, everyone? If there is no further questions, then it will come to the end of today's sessions already. I will stop the sharing already. I would like to thank you everyone for coming today, for joining us this afternoon. I hope it has been helpful to you. I hope everything that we shared just now is informative and helpful. Thank you. Thank you, everyone. Thank you, Mei Ling. Thank you, Alison. Thank you, everyone, for joining us. We will be putting this on our social media as well after we have done some touch up on the sharings, and then we will share it online. But if you have any question, please feel free to drop us a message or email. We will respond to you as soon as possible. Thank you, everyone. Thank you for your time.
Thank you.
Thank you, KY. Thank you. Thank you.